We're going to go over the security clearance denials or suspensions and the impact on your federal employment. Typically, that involves indefinite suspensions, and that's primarily what we're going to be discussing today. As usually, a security clearance suspension follows, or excuse me, starts, and then the next step after that, as a federal employee, would be the indefinite suspension. All right. So my name is Ryan Nerney. As Taylor indicated, I'm the managing partner of the Ladera Ranch office. My primary practice areas are federal employment and security clearance. My information is up there if you want to get in contact with me after the webinar. Just a little disclaimer here. As it says, the views expressed in this webinar are mine and do not imply endorsement by any U.S. government agency. Additionally, this webinar is for informational purposes only and should not be construed as any type of legal advice that's being provided. All right, so what you will learn today, hopefully what you'll learn today in today's webinar is what is an indefinite suspension, why one of the most common reasons for an indefinite suspension adverse action is security clearance related, how does a suspension or revocation of your clearance elicit an indefinite suspension. As I mentioned before, typically a suspension of your security clearance will elicit an indefinite suspension. A revocation could also do that, but it could also have an impact on your federal employment in general and your continued federal employment in general. Also, we'll go over what are the limited defenses to an indefinite suspension taken against you by the agency. We'll also go over the general case law that allows for indefinite suspensions based upon security clearance suspensions. We'll go over some potential resolution options to an indefinite suspension. And then the last aspect of an indefinite suspension would be appealing to the Merit Systems Protection Board. There's also an aspect as well, I added another slide here to discuss potential for back pay and some questions on that in the event that the indefinite suspension is either lifted or found invalid or what have you. All right, so what is an indefinite suspension? To put it simply, an indefinite suspension occurs when a federal employee is suspended from all duties and employment activities without pay for an undetermined amount of time. This does not mean that there's no end. So as you see below in the case Jones versus Department of Army, in order for an indefinite suspension to be valid, there must be some sort of end or ascertainable end, meaning a condition that is able to be met that will bring the suspension to a conclusion. Most of the time, for a security clearance related indefinite suspension, that means that either the clearance is revoked or that the suspension of your clearance is lifted. There's a full adjudication of your clearance, and ultimately that means that the reason for the indefinite suspension has been remedied, and therefore, it will be lifted at that point. All right, so what are the most common reasons for an indefinite suspension's adverse action, or why, excuse me, is one of the most common reasons for indefinite suspension adverse action security clearance related. So, like I said, indefinite suspensions are essentially suspension from federal employment without pay. There's some other aspects. Sometimes agencies in the past used to put federal employees on administrative leave, which is essentially leave with pay. They still can't perform their duties of their job, but they're still getting paid. Over the last, I would say probably in the last maybe 5 to 7 years, the agencies have shied away from that, essentially because sometimes these security clearance investigations take years, and an employee would essentially be sitting at home, not performing their job, but still getting paid as they were doing their job. So as a result of that, agencies have gone a little bit more in the direction of, in fact, most of them are in this direction of putting employees on indefinite suspension. And the most common ways is if an employee is investigated or prosecuted for a criminal offense. We're not going to go into that too much today, but essentially you can be placed on an indefinite suspension if you are arrested or prosecuted or something like that for a criminal offense. And that ascertainable end that we were talking about earlier would be some sort of resolution to that criminal offense. The more common reason that we see in our practice is if your security clearance is suspended. And I put in parentheses there, if it's revoked in some cases pending an appeal. So sometimes your clearance can be revoked as a federal employee, but you still have the option to appeal via an in-person appearance in front of an administrative judge. If that happens, sometimes you will still remain on indefinite suspension, or you'll be placed on indefinite suspension until that appeal is done and there's an actual final determination on your clearance. But the most common is that your security clearance is suspended. Your security clearance can be suspended unilaterally by the agency itself. So if the agency finds out, and we'll get into this a little bit more in later slides, but if the agency finds out some sort of derogatory information that is a potential security concern, they can unilaterally suspend your clearance. And as a result of the clearance suspension, that could lead to an indefinite suspension. So the underlying reasons for a clearance, security clearance revocation, are not the typical charge in an indefinite suspension, but it's the actual suspension of the security clearance itself, which is the charge, which essentially prevents the employee from meeting a condition of employment. The most common charge for indefinite suspensions based upon the security clearance aspect is a failure to meet a condition of employment. If your federal employment position requires you to obtain and maintain a security clearance. So, in a lot of circumstances, if you're a federal employee, there's a possibility, even if you aren't handling classified material on a daily basis, there's a possibility that based upon your work location or just what you do in general, there's a possibility you could come into contact with classified information. So as a result of that, or even if you do, routinely handle classified material, as a result of that, your position may require you to obtain and maintain a security clearance. So if that is a part of your position, or is a condition of employment, and your security clearance is suspended, then at that point you won't be able to meet that condition of employment. So again, because your security clearance is suspended, which typically entails the removal of all access to classified material and locations, you're unable to perform the essential duties of your position, and therefore the most common charge there is a failure to meet a condition of employment. Indefinite suspensions are used in lieu of removals in this because there's no final determination made on your clearance. So a lot of times, I have individuals ask me, why don't they just remove me if my clearance is suspended? And the reason why is because that even though your command or your agency has the ability to unilaterally suspend your clearance, they do not have the authority, at least, your direct supervisors or HR, anybody like that, they don't have the authority to actually make a decision on your clearance. That typically relies with a third party. Most common one is on the Department of Defense side, which is with DCSA, the Defense Counterintelligence Security Agency. And they're the ones that actually are the agency that is able to make a final determination on your clearance. So because there's no definitive determination made on your clearance yet, then the agencies typically put you on an indefinite suspension. And especially if the final clearance determination is favorable, then the clearance suspension would be lifted at that point, along with the indefinite suspension. So if they remove you, that essentially is premature. for if there hasn't been a determination or final determination made on your clearance. All right. So how does a suspension or revocation of your security clearance elicit an indefinite suspension? So we kind of went over that a little bit in the last slide, but essentially, in order for a security clearance suspension to be enacted, the agency or a military command must have a legitimate concern that continued access to classified material or locations would be detrimental to government interests. So this is important, and that's kind of a broad way that agencies utilize this. But essentially, if there's some sort of issue, whether it be criminal conduct, whether it be reporting of foreign contacts, whether it be mishandling of classified material, anything along those lines, financial concerns even, maybe you pop positive on a drug test, any concerns like that could eventually or could potentially be a security concern and could elicit a security clearance suspension by the agency itself or the military command. Typically, if this happens, an incident report is placed in an employee's Defense Information System for Security, commonly known as DISS. Used to be called JPAS, but that has since transitioned in the last couple of years. Or scattered castles. Scattered castles is the DISS equivalent of intelligence agencies. Same thing. And if that incident report is placed in one of these two systems, that triggers an investigation by a designated investigator and adjudicators for your security clearances. So you heard me mention a little bit before DCSA. DCSA is the one on the Department of Defense side that there's various different divisions of DCSA. There's an investigative division and an adjudicating division. If there's an incident report placed in your DISS, that notifies, in this case, it would be DCSA, that there's some potential security concerns, which again triggers an investigation, and ultimately there would be a determination made by an adjudicator on whether you should retain your clearance or whether they're going to revoke it and then provide you some appeal options. As I previously mentioned, once a security clearance is suspended and a clearance is a requirement of your position, you can be placed on indefinite suspension without pay pending the final adjudication of your clearance. A clearance suspension usually happens, like I said before, if there's some sort of security concern, if you will, whether you are self-reporting some potential security concerns. Usually that's some sort of like criminal aspects where, let's say you get a DUI or something like that, you would report that to your security officer, which probably would elicit an incident report. If there's some derogatory information discovered through what they call a continuous evaluation or periodic review as part of your clearance. If there is another employee that reports a legitimate security concern, let's say another employee sees that you are mishandling classified material or that you are misusing some information technology systems, something along those lines, that can be reported to the security officer, and that could also elicit an incident report. There also could be some derogatory information discovered through routine processes and procedures conducted by the agency. The most common of that would be, random drug tests. If you pop positive on a drug test, that's obviously would be a security concern, and that could also elicit a security clearance suspension, and an extension would most likely elicit a indefinite suspension. Now, it's important. One thing to note is that even if there are some security clearance concerns, although the agencies and military commands should most likely suspend your clearance at that point, it actually is somewhat in their discretion, so they don't actually have to suspend your clearance. Most of the time they do in order to cover themselves, but they don't absolutely have to. But again, most commonly and most of the time, if there is some sort of security concern that they are notified of, they will submit an incident report and also suspend your clearance pending the final adjudication of your clearance by that third party we were discussing before. If you are placed on a indefinite suspension based upon your security clearance suspension, that's there are limited defenses to that. And the reason why there are limited defenses is because, like I said before, if there are legitimate security concerns, an agency has the right and ability to not only suspend your clearance, but also if they suspend your clearance and again, you don't meet a condition of employment, then that would make essentially the indefinite suspension, um, I guess, for lack of a better term, legitimate. So a lot of times in my practice, I see individuals say, well, the security clearance suspension should never have been put in place. The reasons for it are not valid, things along those lines. Unfortunately, if you are placed on an indefinite suspension, and the actual reasons for the clearance suspension are not a part of that indefinite suspension charge, then you will not be able to essentially argue the underlying reasons for the security clearance suspension. The Supreme Court has determined that any appeal under 5 USC 7513, which an indefinite suspension would be, that was based upon the denial or revocation of the security clearance. Later, they'll add security suspension, which is the most common one at this point. The Merit Systems Protection Board, does not have the authority to review the substance of the underlying security clearance determination. As I said before, this was later expanded to security clearance suspensions. But this was laid out in a very famous, and honestly, it's probably the security clearance case, Department of Navy versus Egan. And you see Cheney versus Department of Justice as well. That was the case that later expanded the findings in Egan to include security clearance suspensions along with revocations and denials. So because there can't be any discussions by any deciding official or by any board on the underlying reasons for a security clearance suspension, it makes the defenses to that limited to the next two aspects, which are due process issues or harmful error issues. So due process rights afford an employee whose access to classified information has been suspended to be notified of the agency's determination regarding an employee's access. So essentially, a letter indicating that their clearance has been suspended, a statement of reasons for that determination, and then an opportunity to respond. Now, it's a little gray area in this because sometimes clearance suspension letters don't allow for an opportunity to respond. But if you get an actual statement of reasons, which would come from that third party organization that we were talking about earlier, with the statement of reasons, then you do have to have an opportunity to respond. Not all security clearance suspensions allow this. Most do. But sometimes they just wait and say, if you're going to get a statement of reasons issued by that third party, then we don't need to provide you an opportunity to respond to the actual suspension itself. However, if they don't give you that opportunity to respond to the suspension, that is something that potentially could be argued as a due process violation. Now, like I said, that's kind of a gray area there. So it is kind of up to the interpretation of any type of MSPB judge or a deciding official before you get to MSPB on how they want to interpret that. But you should get an opportunity to respond to that. And then eventually, again, if the suspension is upheld, you're placed on a definite suspension. If there are some additional issues or concerns related to your clearance, then, let's say the Department of Defense aspect, DCSA will issue a statement of reasons. You'll have an opportunity to respond to that. Although a board may not review the underlying reasons for a clearance suspension, like I said before, the MSPB has a job to ensure, as well as the agency has a job to ensure, that the agency provides the procedural protections that are guaranteed by 5 USC 7513. So like I said before, indefinite suspensions are governed under 5 USC 7513. And because of that, there are due process aspects that have to be followed. And this goes primarily for the indefinite suspension. So the 5 USC 7513 are based upon the actual indefinite suspension itself, not the underlying reasons for the clearance suspension, like I said before. So you have to be provided at least 30 days advance written notice unless there's some sort of reasonable cause to believe that you've committed a crime as an employee, which, a sentence of imprisonment may be imposed. You have to be provided a reasonable time, but not less than 7 days to answer orally and or in writing to furnish any affidavits, other documentary evidence that would support your response and your side of the story. You have a right to be represented by an attorney or any other representative of your choice. And then there must be a written decision provided to you, as well as the specific reasons for that at the earliest possible date. So essentially, they have to give you something. Typically, the way they do this is a proposed indefinite suspension, giving you a certain period of time to respond. Again, the most likely charge would be is that you have a failure to meet a condition of employment, and then you have to have an opportunity to respond to that and reasonably respond to that. So if the agency does not follow any of these aspects, that potentially could be a due process issue that could actually overturn an indefinite suspension, even if the actual failure to meet a condition of employment is accurate. So again, the due process issue is one aspect of your limited defenses. The next is harmful error issues. So a harmful error occurs when any procedure or process is not followed or properly followed based upon the agency's own regulations. So the difference there is, as we discussed in the due process, that's based upon some case law as well as federal regulations, which are 5 U.S.C. 7513, subsection B. The harmful error issues come with the agency's own regulations and them not following that. So to prove that there's an actual harmful procedural error, you must prove that the agency committed a harmful error in the application of its own procedures that would have essentially changed the outcome of your case, absent any cure of the error. So essentially what this means is that if let's say the agency has some sort of regulation that says that they have to provide you 14 days to respond as opposed to just 7, and they only give you 7 days to respond. Well, if they're applicate, and let's say within that additional 7 days, you could have got additional evidence, or you could have got, some more affidavits or something along those lines that would have changed the outcome of the case. That potentially could be a harmful error issue that you could raise as a limited defense to the actual indefinite suspension itself. So essentially, you're kind of left with, two defenses to a indefinite suspension based upon a clearance suspension. Which is the due process issues and the harmful error issues. All right. So there's some general important legal cases and regulations that are important to know with these types of indefinite suspensions. As I mentioned before, the Department of Navy versus Egan, probably the most famous security clearance related case there is. Which was decided by the Supreme Court in 1988, essentially determined that the board, the MSPB, does not have the authority to review the underlying reasons for a clearance suspension, denial, or revocation. Egan is a there's a lot more to Egan than just that, but for the purposes of what this presentation is for, we're only going to focus on the board's lack of authority to review the underlying reasons. So that's the important aspect to take away from the Department of Navy versus Egan, is that aspect. The next case that's important to know is Jones versus Department of Navy. Essentially, that case determined that due process is provided if the agency furnishes an employee with some indications of the reasons for the agency's decision to suspend access to classified information before being placed on an employee on a definite suspension. So that kind of goes to the due process aspect that we were talking about earlier. But realistically, all the agency needs to do is to provide you a notice saying, hey, your clearance is suspended, and that would be sufficient enough to meet the due process aspect. Again, like I said, typically they give you a certain time to respond to the actual suspension itself before they place you on a definite suspension. Um, it's kind of a case by case basis there, but the agency does need to provide you with some sort of reason for the suspension access, whether that just be, hey, this is a guideline E aspect, and therefore we're, suspending your clearance, something along those lines. It doesn't need to really be as detailed as like the actual proposed adverse action needs to be. The next important case to know is King versus Alston. This essentially provides jurisdiction to the board to ensure that the employees were provided the minimal due process before they were suspended. So this is, kind of going over what was in 7513, 5 USC 7513 that we discussed before, as far as those four aspects of due process. Again, the 30-day notice, reasonable opportunity to respond, representation, and then also a written decision. So that case kind of codifies that. The next is Hess versus Department of State. This essentially provides the board with the authority to review only whether the employee's position required a clearance, whether that clearance was denied or revoked, and whether the employee was provided the procedural due process, and whether a transfer to a non-sensitive position was feasible. Excuse me. And we'll get into that in a little bit as far as what is determined to be feasible and not. But essentially, that is the case that kind of backs up what I was saying previously, which is that the board can't review the underlying reasons for the clearance suspension. They can only review those aspects if the indefinite suspension is based upon a failure to meet a condition of employment, which is the security clearance aspect. The 5 USC section 7513B that we discussed before, that's obviously important because it ensures that an employee is provided and it lays out what the actual statutory procedural protections are that the agency must follow before placing an employee on indefinite suspension. Again, this is usually done via a proposed indefinite suspension, giving the employee an opportunity to respond and provide their side of the story. But again, the defenses in that are limited because it's really only due process or harmful error. Again, if the agency unilaterally suspends your clearance and that is a condition of employment, they're pretty much able to put you on indefinite suspension in order to make sure that the interests of the government are not harmed. The next case to know is McGriff versus Department of Navy. I just noticed that many of these cases are versus the Department of Navy, which is interesting. But the next case is McGriff versus Department of Navy, and this essentially determined that due process requires the opportunity to make an effective reply to an indefinite suspension. But an agency may indefinitely suspend an employee pending a determination on a security clearance issue. So again, this just reiterates the fact that you can be placed on indefinite suspension pending the final determination on a security clearance issue. So this case kind of gave the agency the ability and authority to do just that, what they've been doing for the last few years, which is placing employees on indefinite suspensions with clearance suspensions. Cheney versus Department of Justice, we talked about this case before, but essentially this just extends the findings of Egan to be applied to suspensions of security clearance and not just revocations or denials. And in fact, like I said, suspensions of security clearances are actually the more common one that are used for to elicit an indefinite suspension. Jones versus Department of Army, we discussed this case before, but it indicates essentially that for an indefinite suspension to be valid, there must be an ascertainable end, which is, again, a determinable condition subsequent that will bring a suspension to a certain end. So again, in security clearance suspension cases, that's essentially the final adjudication of a clearance, whether that be, by DCSA for Department of Energy, whether that be by the Access Appeal Panel for the NSA, the adjudicators for, various different agencies. That's where that comes into play. Another case, it's a little bit more recent, from 2015, but this is another big case, Ryan versus DHS. It essentially determined that it doesn't matter really the basis for the clearance suspension if they've changed over time. It only really matters if the security clearance suspension the indefinite suspension was valid at the time that it was initially done. So, for instance, there's no new notice that is required if, let's say, your case is. So, here's an example. Sometimes people get their clearance suspended because of some sort of criminal conduct, right? There's an incident report that is submitted that is discussed, and there's no final determination by, in this case, let's say DCSA CAF for your clearance. So even if throughout that process, you are acquitted of, any wrongdoing, if there has been no final determination on the security clearance by DCSA, then that indefinite suspension can remain in place. And what this case says is that there's no new notice that is required to include a reply opportunity or anything like that. Should, again, the circumstances change that initially caused the security clearance suspension. So essentially, if something like that happened, that would be beneficial, and it obviously would help with the final determination of your security clearance. But you could potentially be kept, and likely would be kept, in the indefinite suspension limbo, if you will, until that final determination is made by the security clearance adjudicators, even if that criminal conduct was remedied. Makes it a little bit complicated, but that's essentially what Ryan versus DHS was going through. Now, as I mentioned before, as part of the process, the due process for indefinite suspensions, you usually are provided a proposed indefinite suspension, and you have an opportunity to respond or orally reply, things like that. If a written decision comes back and that written decision upholds the indefinite suspension, which, if I'm being honest, most of the time it does, if it's, again, based upon that failure to meet a condition of employment, then essentially you'll have the ability to appeal via MSPB, the Merit Systems Protection Board. Because that suspension is over 14 days, MSPB, in order to review the determination by the deciding official from your agency. Now, as I said here before, it's important to note that MSPB only has jurisdiction over the indefinite suspension itself and the charge. So again, the failure to meet a condition of employment. Oops. Sorry. So a failure to meet a condition of employment. But again, they can't look at the underlying reasons for a security clearance suspension. They don't have the authority. Second here. There we go. They don't have the authority to look at anything outside of the actual reasons that are charged on the proposed, and then also the final decision on the indefinite suspension. And I've said that a number of times throughout this presentation, but I think it's important to keep reiterating that because, like I said, it's very important to understand that, and I get this all the time, that an agency cannot look at the underlying reasons for a clearance suspension. So even if the underlying reasons for that clearance suspension end up being not valid, if they were valid, meaning that if the actual indefinite suspension was enacted because of your clearance suspension, even again, if the underlying reasons for that clearance suspension weren't valid or they were wrong or something like that, the agency can still put you on indefinite suspension until there's a final determination made. And MSPB cannot look at any of the reasons for that clearance suspension, and that was, again, codified in Department of Navy versus Egan. Again, the MSPB can only look at those four aspects, like I said before. If the agency provided you proper due process, or if there was some sort of harmful error in the application of their process to elicit that. The MSPB could realistically only look at, if your position required you to have a clearance, and if it did, and it was subsequently suspended, if that was valid, and again, you had the proper due process aspects to it. 30 days after the effective date of the decision to enact the indefinite suspension is the deadline if you do want to file an MSPB appeal. And if there are some due process issues or something like that that you want to argue to MSPB, then that would be something that that you would want to do within 30 days of that effective date. All right, some resolution options. So essentially, they're kind of limited. Again, one of the things that one of the cases I was talking about earlier was potential or finding if it's feasible to place an employee in a non-classified or non-sensitive position pending the outcome of the clearance. So, like I said, in Hesper's Department of State, it provides that the board's authority is to review only whether an employee's position required a security clearance. If that clearance was denied or revoked or suspended, as codified, further in Cheney, whether the employee was provided the procedural due process, and then the last aspect, which is whether the transfer to a non-sensitive position was feasible. So that's again a little bit of a gray area, but the agency is not required to place an employee in a non-classified position. They only have to essentially determine if it's feasible. So if there's no open positions, if you don't meet the qualifications for the position that is non-classified, or if it would cause an undue burden on the agency, which is a lot of times the agency hides behind, then it would be determined that it's not feasible to transfer you to a non-sensitive position. So that's why the agency is not really required to place you in a non-classified position. They just need to basically determine if it's feasible or not. Some agencies are willing to do that if they have an open position and you're a really hard worker. Some agencies are open to placing you in a non-classified position pending the outcome of the security clearance determination. But a lot of times agencies just don't want to deal with that. But that is something that you could potentially broach as a point to ask, the agency if this situation happens to you. Another resolution option would be potential settlement. Potential settlement to resolve the indefinite suspension could potentially be a resignation with a clean SF-50. That's kind of an extreme aspect, but it's a way to kind of not have to worry about the indefinite suspension and not getting paid for a period of time. Or again, transfer to another position that doesn't require clearance. Again, we just talked about that. That's kind of the if feasible aspect of it. And again, agencies are not required to put you in a non-classified position. They only have to find out if it's feasible to transfer you to one. Most of the time it's not. Another resolution option, and this is pretty much the most common way that these resolutions or these indefinite suspensions are resolved, is a clearance determination. So obviously the best case scenario would be that you obtain a favorable security clearance decision. At that point, the reason for your indefinite suspension, which is a failure to meet a condition of employment, would no longer be accurate, and therefore the indefinite suspension should be vacated, and then you should be placed back into your previous position. In some cases, it could take anywhere from a few months to I've seen as long as a couple years for security clearance determinations to come down. So in that case, sometimes your position wouldn't still be there, but the agency would be required to put you back in a comparable position or comparable position if your previous position was backfilled. This can actually happen at any stage in the process. So this could happen at the time you get the proposal. This could happen at the time you get the decision. This could happen at the time that you are at MSPB. Or this can happen, let's say you go to MSPB, you don't get a favorable decision. This can also happen after the fact. So if you get a favorable security clearance determination, that essentially resolves the indefinite suspension, and that should subsequently be vacated. Another aspect which could be resolved, which would not be the best case scenario, would be if you get an unfavorable security clearance determination. So what would happen in that case is that the suspension of your clearance would still be in place, but then there would actually be a revocation. Sometimes, as I mentioned at the very beginning of this presentation, sometimes the revocation does have an appeals process, and sometimes the agency will allow you to stay in that indefinite suspension process until the appeal board has a final determination. However, that is not always the case. Sometimes agencies, if there is a final determination, let's say by DCSA CAF, even if you do have an appeal option, agencies are not obligated to keep you on indefinite suspension if there has been what they consider a final determination by DCSA, which would be a revocation of your clearance. So, and that's obviously, like I said, the worst case scenario. If your clearance while you're on indefinite suspension is revoked, at that point, you usually, for DOD, it's 12 months, for other agencies, it's 2 years, but you usually have to wait a period of time before you can reapply for security clearance. And in which case, you're not going to be able to meet that condition of employment. There's a final decision on your security clearance, which was a revocation, and therefore that ascertainable end was met, but it was unfavorable to you. So therefore, because you can't meet a condition of employment, there's no active investigation on your clearance at that point. The next stage for the agency would likely be to propose your removal, which would likely be enacted because, again, you don't meet that condition of employment, and there's no ongoing investigation or adjudication of your clearance because that decision has already been made. So if your clearance is revoked, the most likely next stage for the agency would be to propose your removal, and you would likely be removed from federal employment. Again, the same due process issues apply. You can still appeal that proposed removal. But most of the time you're not going to be successful in that, again, based on the same reasons that we discussed previously. All right. One of the questions that I get a lot is back pay. So in a circumstance where, let's say your security clearance is reinstated, let's say it's a year down the line, and the indefinite suspension is subsequently vacated. A lot of times people ask, well, what happens? Can I get back pay for that time that I was on indefinite suspension? And the short answer is no. As it says here, a security clearance is a privilege. It is not a right, and therefore there's no property interest in a security clearance, as there would be for employment. So for instance, if you're removed from employment, you file an appeal to MSPB, and subsequently that removal is overturned. At that point, you would be entitled to back pay because there's a property interest in your actual employment. However, on a security clearance side, if there was a legitimate reason for that security clearance suspension, revocation, what have you, at that point, then that's all that needs to be determined in order to essentially reject back pay. So in the case of Jones versus Department of Navy, as you see below, the MSPB has routinely and consistently rejected claims for back pay when security clearances were ultimately restored, even if one of the security clearances, even if one's security clearance is restored and the indefinite suspension is lifted, because the indefinite suspension was valid at the time it was enacted. So if you have the removal aspect, essentially the argument would be is that the removal was not valid because for one reason or another, and therefore you'd be entitled to back pay. In a circumstance like this, if you don't meet a condition of employment at that time, your clearance was suspended, the indefinite suspension was valid, and therefore you shouldn't be entitled to back pay. That's the MSPB's, the board's view of this. And there hasn't really been any case law that has come around to refute this. So the short answer for this is that if you are on indefinite suspension for a period of time and your clearance is subsequently reinstated, the clearance suspension is lifted and the indefinite suspension is lifted, you still wouldn't be entitled to back pay because the indefinite suspension was valid at the time that it was issued. All right. So now I know that there's a lot of questions here, so there's a few questions that I'm going to go over. These are some of the ones that we got from the registration that that you guys submitted. So, first question: can you get your clearance back if you have demonstrated good work performance? Um, in the context of this question and in the context of this presentation, um, the short answer would be no, but it is a good aspect for mitigation. So, for instance, just because you're doing good work, if your clearance is suspended or revoked or something like that, doesn't mean that just because you're doing good work would mean that you would get your clearance back. The clearance is, as I said before, based upon or clearance adjudication is from a third party. The third party isn't really going to care if you're continuously doing good work in the context of getting your clearance back. Now, eventually, that could be beneficial information, as I mentioned before, for mitigation. In the security clearance realm, we do something, or we look at something called the whole person concept, which does take into account, your work ethic, your performance evaluations, lack of discipline, things like that. That could be mitigating conditions and mitigating information that can be included. So eventually, it could be an aspect of getting your clearance back, but just solely demonstrating good work performance is likely not going to be the sole reason that you're going to be able to get your clearance back. You still have to go through the whole adjudicative process. What options do you have as a federal contractor if your clearance is suspended? Not many. Um, Not many. And the reason why I say that is because federal contractors are usually contracted through a private company. Now, that private company has some sort of federal contract with the federal government. And ultimately, even if, let's say, you work for like Raytheon or Northrop Grumman or something like that, so even if one of those companies is the one that's sponsoring your clearance, the ultimate holder of your clearance is the Department of Defense. But because it's a private company, um, you, your options are limited. You're not under the same guise, I guess, as a federal employee. So federal employees have a lot of protections. They have, the Merit Systems Protection Board. They have, a whole bunch of things like that. Whereas if you're a private company, you kind of have to go through the private company's own processes. So realistically, there's nothing that you can really do at that point as a federal contractor. However, there still is a due process aspect for federal contractors. So it's a little bit different for federal contractors versus federal employees as far as clearance adjudications. For a federal contractor, you get a statement of reasons issued, and you go to a hearing before a final decision is made to revoke or deny your clearance. On the federal employee or military side, you respond to a statement of reasons in writing. A decision is made at that point to either revoke or deny your clearance, and then you have an appeal option of going to a hearing in front of an administrative judge. So the process is a little bit different, but ultimately the ultimate goal and outcome is the same. Is there's either going to be a final determination on your clearance or not. So again, long story short, federal contractors, because they work for private companies, even if they are working on a federal contract, clearance suspensions, determinations, your options are kind of limited in that circumstance. Can a federal employee have their clearance revoked without being given an opportunity to respond or appeal? Short answer is no, but there's a caveat to that, which is kind of a backdoor way that agencies use, I guess, to try to avoid the entire adjudicative process. So if you are already employed with the agency and you've been employed with the agency and you're past your probationary period, you would have to be provided the due process that is common for security clearances. So, for instance, you have to be provided, a statement of reasons is the common term, which would lay out the specific allegations or security concerns that the government has. And then you would get a certain opportunity to respond to that, and most of the time get an opportunity to, have a hearing in front of an adjudicative body, appeal panel, or, an administrative judge. And I say there's some caveats to that because sometimes what happens is that before you're employed by the agency, they have you kind of do what they call an SF-86 or an EQIP, something like that. And what they potentially could do is if they look at that and they see that there's going to be some issues with you obtaining a security clearance, then at that point they could just withdraw the job offer before you have an opportunity to go through the entire adjudicative process. So that's kind of a backdoor way that federal agencies kind of use to get out of that. But if you're already employed as a federal employee, then you have to go through that whole aspect of getting a statement of reasons issued and being able to respond to it. So short answer is if you're a federal employee and you're already employed with them, you are entitled to due process to respond to any type of security concerns prior to a final determination to revoke or deny your clearance. Again, with those couple of caveats that I indicated before. Last question I have here is what should you do if you do not receive any explanation to a security clearance denial? So this question says security clearance denial. As far as the suspension goes, we kind of already spoke about that. If your security clearance is suspended, then the agency needs to provide you some sort of, reasoning, even if it's just a minimal reasoning and notification, I should say, that your clearance is suspended. If you don't receive an explanation regarding a security clearance denial, some agencies don't do that. Some agencies don't provide you with, an actual explanation. And the regulations don't necessarily require an actual explanation as to why your clearance was denied. Most of the time, if you're going like DCSA or you're getting in front of an administrative judge, you will receive an actual written decision from the judge, which lays out the explanations for the clearance denial. In other agencies, let's say like the NSA, if you go in front of an access appeals panel, if your clearance is denied, they literally just say your clearance is denied. They send you a letter that says your clearance is denied based upon the reasons that were in the statement of reasons, and they don't really give you a full explanation for that. So realistically, if you don't receive an explanation to a clearance denial, you're depending on the agency, you're not really entitled to. If it's an agency that routinely does provide that, like let's say a decision from an administrative judge or something like that, and you don't receive the actual decision, then that would be something that you probably would want to follow up with your security officer. But again, not all agencies are required to provide that to you. All right, let's see if we have. I'm going to stop sharing for a second to see if we can get if there's any additional questions here. All right, one of the questions is can a clearance be denied if a contractor is released by a private company without explanation, and how do you handle this on an EQIP or SF-86? So this is a little beyond the subject matter of this webinar, but I guess I can answer that question anyways. Essentially, it could be. It depends on what the reasons are. Even if you're not provided with an explanation as far as being released by a private company, when they do their investigations for a security clearance, you obviously have to put down your past. Employment history. And as a result of that, you would have to notify them that you were released from that company and that you're not aware of what the explanation or the reason for that would be. But during that investigation, the investigator could potentially contact that company and obtain that explanation, at which point you probably would be notified of that during any subsequent interview. And then you'll have to kind of explain, what those circumstances are. But, on an SF-86 and a EQIP, you want to make sure that you're 100% truthful. So, when you're filling that out, if you absolutely don't know the reason for, your release from that company, then that would be something that you would want to put down. But you absolutely should indicate that you were released from that company, whether it be fired or whatnot. You need to make sure that that's disclosed. Another question I got is, how do resignations impact security clearances for federal employment? Um, excuse me. I guess it depends on what the actual resignation or the reason for the resignation is. So, for instance, if you resign in lieu of termination, let's say that you're going to be fired, but you resign instead, that still would be something that you would have to disclose on any future SF-86. And that is something that potentially could be an issue that could be looked into. It again depends on the circumstances there, but it could raise some red flags if you resigned in lieu of termination. You'd have to provide the reasons for that resignation and what the actual reasons that they were going to terminate you for on your SF-86. And that could have an impact on not only your security clearance, but also for future federal employment. A lot of times for federal employees, you have to fill out a form called an OF 306, which does go into past employment and things like that. So if there are any employment issues, any discipline, anything like that that you've received, that could potentially be an issue that could impact not only your security clearance but future federal employment. Thank you everybody for taking the time. I think that'll do it for today. I appreciate everyone attending, and I hope you found this webinar informative. Thank you so much.